Good afternoon, and welcome to this month's HR Advanced subscriber webinar. I'm Paul Munro, IR writer for HR Advanced and its sister publication Workplace Info. Today we're going to tackle some of the common types of questions that we receive from subscribers about our key topic for this month, issues regarding leave. We're going to go through 5 actual questions we've received about accrual of annual leave while on workers' compensation, the meaning of domestic or other pressing necessity, and how to handle an employee who is converted from part-time to full-time when calculating long service leave, parental leave issues, and unexpected emergencies in relation to carers leave. We've designed today's webinar for those of you who need a quick grab of information during your lunch break. This webinar will take only 20 minutes of your time. While I'm not able to answer questions during the webinar, please feel free to submit any questions you have on the feedback form, which will appear on your screen at the end of the webinar, and we'll tackle them either directly or as future Q&As on HR Advanced and Workplace Info. So today's first question relates to annual leave, and does it continue to accrue when employees are absent on workers' compensation? This is an issue that has been the subject of a recent full court of the Federal Court. Question is, our company has a number of employees absent on workers' compensation. The company has operations in Queensland, New South Wales and Victoria. All of these employees are long-serving and have been absent for periods in excess of 6 months. It is coming to the point where the company will assess whether to maintain their employment. It has come to our attention the company has not been accruing annual leave during their absence on workers' compensation. Our advisors tell us accrual of annual leave is dependent on the relevant state workers' compensation legislation. Is the company liable to accrue annual leave during an absence on workers' compensation for our employees employed in each of these states? The accrual of annual leave when an employee is absent on workers' compensation depends on the relevant workers' compensation legislation in the state or territory where the employee is receiving compensation. This issue in relation to New South Wales workers' compensation was recently determined by the full bench of the Federal Court. Firstly, though, in Queensland, the Workers' Compensation and Rehabilitation Act allows an employee to take and accrue annual leave during the employee's absence on workers' compensation, so no issue there. New South Wales has always been a bit problematic. The Workers' Compensation Act permits the taking of annual leave, a public holiday, and long service leave during a period of workers' compensation. A full court of the Federal Court interpreted this situation in its recent decision, which upheld an order that required an employer to pay a former employee employed in New South Wales the annual leave she accrued while absent from the workplace on workers' compensation. The decision confirmed that employees receiving workers' compensation are also entitled to annual leave accrual. The impact of this particular decision may have ramifications for other states and territories' workers' compensation legislation where the terms are similar to the New South Wales Act. For example, in Victoria and Western Australia, the relevant workers' compensation statutes contain terms similar to those provided by the New South Wales legislation, which allows an employee who takes annual leave and continue to receive payments of weekly compensation at the same level, which is under the Workplace Injury Rehabilitation and Compensation Act in Victoria and the Workers' Compensation and Injury Management Act in WA. Employers in these two states should take into account the possibility of a similar outcome if the relevant legislation is challenged before the Federal Court. In South Australia, the Return to Work Act permits an employee to take or accrue leave while also receiving workers' compensation payments. Consequently, the full court decision would not impact on this legislation. In Tasmania, The Workers' Rehabilitation and Compensation Act contains provisions that prevent double dipping so that a worker cannot receive weekly payments of compensation and paid annual leave simultaneously. In the Australian Capital Territory, the Workers' Compensation Act states that the Act is not intended to affect an entitlement that the worker has a benefit or payment unless otherwise provided by an ACT law. Examples of benefits not affected include accrual of long service leave and accrual of annual leave. Under the Workers' Compensation Rehabilitation and Compensation Act in the Northern Territory, there aren't any relevant provisions, so it's unaffected. So the bottom line is, while the Fair Work Act provides that an employee does not accrue or can take annual leave when absent on workers' compensation, the relevant state or territory workers' compensation legislation may provide otherwise. There may have been mentioned in previous webinars, in particular with New South Wales, there's been this debate. That's the reason that this matter ended up in the full court of the Federal Court. There's been this debate in that jurisdiction regarding the relevance of the workers' or the effect of the workers' compensation legislation. So that has now been determined at the second highest level court in the country, so it will stand in that respect. So issue 2 is dealing with payment of pro rata long service leave and what is domestic or other pressing necessity. This isn't something that appears in every piece of legislation, state or territory long service leave legislation, but certainly in the majority it does. One of the questions we had recently regarded an employee who resigned for personal reasons and whether there was an entitlement to pro rata long service leave on termination because of a domestic or other pressing necessity. So the question was as follows. We have an employee who resigned from their employment last month after 8 years continuous service with the company. The reason given for the resignation was due to personal reasons, the employee wanting to spend more time with his family. He has now contacted the company claiming payment of pro rata long service leave due to domestic necessity. The relevant legislation, which is the New South Wales Long Service Leave Act, refers to termination by the employee due to domestic or other pressing necessity as a reason for an entitlement to payment once the person has completed 5 years service. Under what circumstances would the employee qualify for pro rata long service leave in this situation? So the answer is that in situations such as this, it's difficult to give a definitive answer as the courts consider that the test of what is domestic or pressing necessity is a subjective one and not an objective one. The term pressing necessity conveys the existence of a state of affairs that necessarily require the employee to terminate his or her employment. In assessing an employee's claim, courts generally consider the following. Does the reason for termination fall within the scope of domestic or other pressing necessity? Was such reason genuinely held by the employee and not simply colourable or a rationalisation? The reason claimed may not be the sole ground which actuated the employee in his or her decision to terminate, but was it the real or motivating reason? Or was the reason such that a reasonable person in the circumstances might have felt compelled to terminate their employment? In this case, the employee may have to provide more detail about the motivating reason to spend more time with his family. If, for example, the employee resigned to perform home duties because his spouse could not cope with the current domestic situation, this could be considered a domestic necessity. Certainly, if the main reason was due to accepting carer responsibilities, this circumstance would qualify for pro rata payment. Similar terms referring to an employee's resignation due to domestic or other pressing necessity exist in other state and territory long service leave legislation. While Victoria, South Australia and Western Australia legislation provide an entitlement to pro rata payment after completing the specified qualifying period the employer resigns for any reason, all other state and territory long service leave legislation qualify entitlement to the reason for resignation being due to, amongst other things, domestic or other pressing necessity. Courts and tribunals in those jurisdictions would normally apply the above test when considering whether the reason an employee resigned was due to domestic or other pressing necessity. So the bottom line is that the important word in all of this is necessity. That the employee needs to determine whether the reason for resignation is genuine. While the employee should ask the question of themselves, would I have resigned if such circumstances happened to me? Once again, on the topic of long service leave, actually after unfair dismissal, the Ask an Expert service with Workplace Info, long service leave is the second most asked topic, funnily enough, for reasons which I'm not exactly sure why, but it certainly is always the second most asked topic. One of the questions relates to, one of the issues relates to an employee who changes from part-time to full-time and how that affects their long service leave. Should the leave be paid at their current rate, or do they average the hours worked over a certain period? So we received a question recently on that particular point. We have an employee whose employment changed 6 months ago from part-time to full-time. The employee has been employed for over 10 years and has requested 2 months leave commencing next month. Our payroll department has questioned the rate of pay the employee should receive when taking the leave. Is the employee to be paid at their current full-time rate of pay or an average over a specified period? The employee is employed in Victoria. Once again, this will depend on the state or territory long service leave legislation that applies in where the employee is employed. In this case, the Victorian Long Service Leave Act states that where an employee's ordinary hours have changed in the 12 months immediately before the employee takes long service leave, the employee's hours for calculating long service leave would be averaged over the preceding 12 months or 5 years, whichever average hours is the greater. This applies in cases where the employee's hours of employment alter. For example, an employee may move from full-time to part-time employment or vice versa. In this case, the employer would need to calculate the average weekly hours over the previous 12 months from the date of taking the leave. This would mean the employee's ordinary weekly wage would be appropriately 34 hours pay for each week of long service leave. In this case, the employee was on part-time hours for 6 months at 30 hours a week, and they reverted to 38 hours full-time. Applying that average in this particular case works out at 34 hours. In other jurisdictions, the payment for a period of long service leave will vary depending on the legislation. For example, in New South Wales, the long service leave pay is based on the employee's ordinary rate of pay for the last pay period prior to the leave being taken, or the average ordinary weekly wage of pay over the previous 5 years, whichever is the greater. In the case of the ACT, payment for long service leave is at the ordinary remuneration the employee would have received had the employee not been absent on leave. But if within 2 years of the employee becoming entitled to leave, the employee ceases to be employed full-time and is employed part-time or as a casual employee, the ordinary pay for the leave is calculated by dividing by 5 the total amount of salary or wages paid to the employee in the 5 years preceding the leave. In Queensland, long service leave is paid at the employee's ordinary rate of pay, that is excluding overtime and penalty rates, current for the period of the leave. In South Australia, the long service leave is paid at the employee's ordinary weekly rate of pay, but excluding overtime, shift premiums or penalty rates. An employee's payment is to be adjusted if a wage increase occurs. If an employee's weekly hours vary or the employment status changes from full-time to part-time or casual, or vice versa, the employee's hours are averaged over the previous 3 years. In Tasmania, the employee is to receive their ordinary pay for the period of long service leave and is based on an average of hours worked over the 12 months immediately prior to the commencement of leave, that is the total hours worked over the previous 12 months divided by 52. Western Australia, long service leave is paid the employee's ordinary rate of pay, applicable at the time the leave is taken. Averaging applies if the employee is casual for part-time at the time of taking the leave. So the bottom line is, check the relevant state or territory long service leave legislation. Although generally an employee is paid at the current rate or an average over a prescribed period of time, whichever is the greater. Next issue is on parental leave. This is a very common question, actually. This is where can an employee take annual leave or long service leave while on unpaid parental leave? We received this question on this particular issue. We have an employee who will shortly be taking 6 months unpaid parental leave. The employee has requested taking all of her accrued annual leave, approximately 8 weeks. While amenable to the request, does the legislation prevent taking annual leave when an employee is already on another form of leave prescribed by the Fair Work Act? Also, could the employee take long service leave? She's completed over 10 years continuous service with the company and is covered under New South Wales legislation. Also, can the employer send an employee on annual leave or long service leave during a period of unpaid parental leave? The employer's obligations depend on the type of leave. In the case of annual leave, Fair Work Act does allow the taking of accrued annual leave during a period of unpaid parental leave, although the employee does not accrue annual leave while absent on parental leave. Under the National Employment Standard, annual leave may be taken for a period agreed to between an employee and his or her employer. An employer cannot unreasonably refuse to agree to a request by the employee to take paid annual leave. The employer cannot direct an award agreement covered employee to take annual leave, this being subject to the applicable modern award. However, under the Fair Work Act, an employer may require an award agreement for an employee to take a period of annual leave, but only if the request is reasonable. The expenditure memorandum to the Fair Work Bill back in 2008 stated that in assessing the reasonableness of a request or direction under the standards, it's envisaged that the following are all relevant considerations: the needs of both the employee and the employer's business, any agreed arrangement with the employee, the custom and practice in the business, the timing of the requirement or direction to take leave, and the reasonableness of the period of notice given by the employee to take leave. Examples of a reasonable request include the employee having accrued an excessive amount of annual leave, such as 8 weeks or more, or the employer's business is being shut down for a period, such as the upcoming Christmas New Year period. In the case of long service leave, taking long service leave is usually dependent on the relevant state or territory long service leave legislation. In this case, the New South Wales legislation does not specifically prevent an employee from taking long service leave during a period of unpaid leave. However, the employer must give at least 1 month's notice when directing the employee to take such leave. In fact, I've not seen a provision in any other state or territory long service leave legislation that would prevent somebody from taking long service leave during a period of unpaid parental leave. But just make sure and check each state or territory, your relevant state or territory long service leave legislation. So the bottom line is that the employer can agree to an employee's request to take annual leave during an absence on unpaid parental leave. Taking long service leave is subject to the relevant state or territory legislation, although generally, as I just mentioned, taking leave while on parental leave is permissible. The last question is on carers leave and what is regarded as an unexpected emergency. There's always a fair bit of confusion actually regarding carers leave, and because it's also tied up with personal leave, which relates to an employee's illness or injury. So I had a scenario recently where an employee unexpectedly has to leave work to collect a child from school. Are they entitled to paid carers leave? This is a question we received from one of our subscribers to Workplace Info. One of our employees is the mother of a primary school child. The employee has a long-standing arrangement whereby a friend usually collects her son from school. Yesterday, the friend was unable to collect the child and rang the employee at work informing her of this problem. The employee was unable to make alternative arrangements and left work 2 hours before her normal finishing time. The employee is claiming an entitlement to 2 hours paid carers leave due to the unexpected emergency created by the breakdown in the arrangement with the friend. The company presumes the reference to an unexpected emergency in the Fair Work Act relates to a medical emergency where the employee is required to provide care or support to the member of the immediate family. So would this circumstance qualify the employee to an entitlement to paid carers leave under the National Employment Standard? As the employee left the workplace because of her responsibilities as a parent, a court could consider this circumstance as an unexpected emergency and consequently be entitled to 2 hours paid carers leave. The ordinary general meaning of emergency in the dictionary is a sudden state of danger, conflict, etc., requiring immediate action, also a medical condition requiring immediate action. The carers leave requirement within the National Employment Standards provides for care or support and hence are alternatives. Further, such leave is not tied to the incidence of illness but can apply to an illness or an injury or to an emergency situation affecting the family or household member. This means an employer may elect to use their personal carers leave to provide support only to a family or household member who was affected by an emergency situation, that is, without reference to illness or injury. Thus, while an unexpected emergency includes a medical emergency, the term also applies to non-medical emergencies. This circumstance was actually considered by the Federal Circuit Court, which determined that an employer who needed to collect her primary school child from school because a friend could not pick up the child as usually arranged was an unexpected emergency for the purposes of paid carers, personal carers leave. So the amount of accrued paid carers leave that can be taken each year is not capped, subject to the employee's accrued balance of leave at the time. An employee who has exhausted their accrued personal carers leave may access up to 2 days unpaid carers leave. The employee must use all of their accrued paid personal carers leave before accessing unpaid carers leave. So the bottom line is that in the context of paid carers leave, the Federal Circuit Court is certainly of the view that an unexpected emergency means not only a medical emergency, but also a non-medical emergency. So you will have to take into account each circumstance to determine whether or not it would be regarded as an emergency, not just a medical emergency. And that's the last of the questions. So thank you for listening in. So I hope you've found today's session useful. Please feel free to drop us a line at customerservice@hradvance.com.au if you have any follow-up questions, and make sure you log on to HR Advance for practical management of your HR work. If you want to revisit today's presentation, an archive will be published on our YouTube channel to watch and listen to at your leisure. The URL will be included in our follow-up email. Our next HR Advance webinar will be in February, so keep an eye on your HR Advance newsletter for more details. Thanks for listening, and as this is the last one for the year, I hope everybody has a happy Christmas and a healthy and prosperous new year. See you next year. Bye.